And so this is just a pure legal issue that we're submitting to the court in advance of
Right,
that trial.
you're arguing that Delgado, the verdict in Delgado case is collateral estoppel on the issue of, in this case.
That's right. So we had a judgment in the Delgado case that found a finding of breach of fiduciary duty. The allegations in the Delgado case regarding breach of fiduciary duty overlap the same allegations of breach of fiduciary duty asserted against Five Star Global LLC, the defendant in this case. What's important in the judgment against Delgado was that Your Honor refused the finding or found that we did not prove our case for the breach of informal and fiduciary duty against Mr. Delgado and purely found a finding that he breached his formal fiduciary duty as the CEO of Five Star Global. And so based off of that, there really, since he is the chief executive officer of Five Star Global, whatever acts or omissions that he ultimately did that arose, ultimately the breach of fiduciary duty is equally chargeable to Five Star Global since he was the chief executive officer during the relevant time period. Of course, we're doing this through inference, which we believe is appropriate in this case, simply because we did not have findings of fact and conclusions of law from the Delgado case. Nonetheless, there's really no set of circumstances that we can perceive which would have allowed Mr. Delgado to have breached a formal fiduciary duty and not have Five Star Global also likewise breach the formal fiduciary duty simply because his acts were the acts of Five Star Global at that time. There was privity, which was another element I know is contested by the defendants simply because Mr. Delgado was the CEO during the relevant time period. His attorneys at the case were also representing Five Star Global at that particular time. They indemnified Mr. Delgado in connection to that trial. Clearly, they were in charge of the litigation and had a seat at the table during that case. I guess the only other issue that is somewhat unusual is that we reached a settlement after the judgment was rendered. And as a part of the settlement, we agreed to vacate the judgment and substitute a take nothing judgment. We have cited, Your Honor, to a number of cases saying that does not vitiate or avoid the application of collateral estoppel simply because there was a settlement and a vacature of the underlying judgment for which collateral estoppel arose. I know the defendant cited to a number of cases saying, well, that's not true. But none of those cases actually says that collateral estoppel was inappropriate based off of a vacated judgment. All of those cases were simply dealing with what happens if a judgment is overturned on appeal, not if a judgment was vacated by agreement pursuant to a settlement agreement. The cases that we have cited, Your Honor, to deals directly with that issue and found that it was appropriate to have collateral estoppel apply in those circumstances. I think the Fifth Circuit, the way that they've articulated is that if a party takes its chances at trial and loses, and then settles the case afterwards, that doesn't mean that person or that party gets to avoid collateral estoppel simply because they paid a settlement in order to vacate the judgment. So with that, Your Honor, we believe that we have proven the elements of collateral estoppel, and we would ask that Your Honor simply
Are any of the cases that you cited to in your briefing have situations where they actually vacated the judgment as opposed to there was a judgment and then it wasn't enforced because there was a settlement?
I believe that the Fifth Circuit case that I had referenced, and I want to get the site to Your Honor, did deal with that, which is the vacature of a judgment pursuant to settlement.
And you said, when you mean Fifth Circuit, do you mean the federal Fifth Circuit or the Dallas Court of Appeals?
It's the Fifth Circuit. We have cited to federal law. We were not able to find a Texas state law Court of Appeals decision directly on point. And so the Fifth Circuit was federal law. And that was Chemitron Corp. v. Business Funds Incorporated, 682 Federal 2nd 1149. It's from 1982. And it was holding that a judgment vacated in accordance with the settlement, so it was a vacature of an underlying judgment, did not lose preclusive effect simply because of a settlement agreement vacating the judgment. So that did deal with the exact same scenario we're dealing with here. And it wasn't just the Fifth Circuit who came to that conclusion. We also have the Ninth Circuit as well as other circuits of appeals. This Sixth Circuit is another one that came to that same conclusion. So while we don't have a Dallas Court of Appeals or Texas Supreme Court opinion directly on point, There are a number of opinions that have held that that was appropriate, and there is no Texas authority that we're aware of that says that is inappropriate. The only authority cited by the other side or the opposition is simply dealing with what happens to a judgment which is overturned on appeal, not one that is simply vacated by agreement.
Response?
Yes. So can I just address that issue sort of out of order while you're on it, which is,
Yeah,
they didn't just vacate the judgment. You entered a take nothing judgment against the plaintiff. So the actual judgment now is a take nothing judgment on the very claim they're asking.
remind me, did I enter a judgment and then they vacated that judgment and then now there's a take nothing judgment, or
Right.
was there just never a judgment?
There was a judgment that the court then vacated. There was an agreed motion to vacate the judgment. The court vacated the judgment and replaced it with an entry of a take nothing judgment. It's the actual language of your order. So today, as we sit here today, there is a take nothing judgment against the claim. They're now asking you to use offensive, not defensive, but offensive collateral estoppel. There is no precedent I can find anywhere where there's a settlement is replaced with a take nothing judgment that you then say, okay, now I'm going to offensively use that. The few cases that are there are defensive, which is I lose, settle, try and get out of it, and then try and do it again somewhere else. And the courts have said, well, that makes sense. Wait a minute, you lost. You can't buy your way out of this. Here you have a plaintiff saying, I have a judgment. I'm going to give it up in exchange for money now, rather than go through the process, risk an appeal. And I'm prepared in exchange for that money to have a take nothing judgment entered against me. Nowhere can I find a case that will allow you to do it.
Mr. Ortiago cited to, did you say Chimchuri case? What was the name of the case?
Yeah, and I can't pronounce it that well either, Your Honor, but it is Chimatron Corporation v. Business Funds Corporation, and that's a Fifth Circuit case where that's exactly what happened, which was the application of collateral estoppel based off of a vacated judgment for offensive collateral estoppel, not defensive. It was an offensive collateral estoppel case.
Can you share screen that case, Mr. Ortiago?
I would have to download it first. So if you give me a second, I can go to
Okay.
Westlaw to go get it.
I may have it as well.
Yeah, that order, which I'm citing at page 1188, it looks like he just dismissed the case with prejudice and withdrew and set aside his findings of fact and conclusions of law. So it doesn't look like he entered a take nothing judgment, at least from what I can tell. I can certainly pull the actual order from the case if that would be helpful to the court.
Yeah, I mean, I just want to see what the court says. Can anyone share screen that?
Yeah, I think maybe we can, Your Honor. Let's give us a second.
Oh no.
Mr. Tillotson, I'm looking at your background there, and I think you're in the wrong courtroom.
It's the only one I could take a photo of, Your Honor.
Okay, I do have the case now, Your Honor.
Oh, it's not even a Zoom background. It's an
No,
actual
it's real. It's a
Wow.
canvas. It's a canvas, so I don't disappear like Back to the Future.
That is really clever.
Sorry, I'm trying to get to the actual start of the case. Here we are. Tell me when you want me to scroll.
I'll just go to wherever it talks
Okay.
about this issue.
Yeah, I'm looking for the pin site. It is 1187.
And Tony, did you see the spelling of that Chimatron? Chemetron, it looks like.
Almost there.
Thank you.
Okay, it starts on 1187. It's right here. Just tell me when you want me to scroll.
Okay. keep going down. Oh, wow. Okay, keep going down.
Okay, so I think the
Okay,
relevant part that we want
what-
starts here.
Yeah, because yeah, none of this is relevant at this point. Okay, I think it's 42 you may be looking for.
Here we go.
Okay, a settlement with no final judgment on the merits have been sent to bar collateral estoppel.
Can I scroll, Your Honor?
Yeah, keep going.
Okay.
Okay, yeah, so this is interesting, but includes many dispositions which, though not final in that sense, have nevertheless been fully litigated. Yeah, I mean, Mr. Tillotson, I'm not sure how you, assuming this would be the law that the state of Texas follows, it seems that, and it makes sense. I mean, if you fully litigated a case, even if this is a situation where it doesn't even look like they had a final judgment in place.
Well, but the issue is offensive versus defensive use. And there's more than just, is it a final judgment? This case says, first, the general rule, which they apply from the Supreme Court Park Hosiery case, is you can't even use offensive collateral estoppel if the people you're trying to use it against could have been added in the action you had. And that's, they start off with whether or not in this particular case, the person you're trying to use collateral estoppel against offensively could have been part of your original case. You know, that's not the case here. All the parties here could have been in the Delgado case, but weren't. So if you're going to go under federal law, you would apply that rule and you would say you can't even really use collateral estoppel. Second, I would argue that it's one thing to say we litigated, but finality, for whatever reasons, don't have a judgment, but where the parties bargained for a release of that judgment, if you will, vacating it, such that we don't want to live with it anymore. I would say that takes you out of collateral estoppel with respect to Mr. Delgado. He paid that money in exchange for vacating the judgment. There's many ways you could have settled this to preserve collateral estoppel. You could have said, look, pay the money, I'll give you a satisfaction of judgment. You could have said, pay the money, let's just dismiss the case without prejudice or with prejudice.
Mr. Tilson, I think based on, if this is good law for Texas, which again, I'm not sure if it is or not, but assuming it's good law for Texas, I think based on this decision, the Chimatron case, then you would, you know, this judgment is I guess, final enough. I mean, they could say you don't even have to have a completely final judgment as long as it was fully litigated.
Right, but that would allow multiple cases. You would file cases all over the place, take your chances and try and win. And I'll just start with the very most important thing, which is a real problem we have procedurally, Your Honor. There's just no way you can do this. There is no procedure for a summary disposition of collateral estoppel. We've cited you numerous cases where courts have been reversed when they try and do collateral estoppel by summary disposition. They say you can't do it that way. They've brought this under 166G, which is the pretrial rule, where we're supposed to identify for you legal matters to be relied on, to be ruled on, or decided by the court.
So, Mr. Tilton, that's a separate issue, though, isn't it?
No, I'm just saying that the problem is when you talk about a final judgment as to what? What facts were finally adjudicated according to that judgment? Answer is the judgment doesn't say, there's no findings of fact, and the judgment's actually been vacated, and as best we know, it's been entered against them. So when you say, all right, collateral estoppel, the claim, breach of fiduciary duty against Mr. Delgado is no longer in any lawsuit. So that not seeking to collaterally estop that claim. They're seeking to collaterally estop the litigation of specific facts related to that claim. So I say, all right, were those facts litigated to finality? The answer is, well, we don't know, because there's no record or findings of fact or conclusions of law that were entered that would allow us to see that. And then, all right, well, what does the judgment say? The judgment says, so take nothing in against them. And they say, but well, we finally litigated it. I would say you finally litigated it to the Delgado prevailing, in the sense, at least from the judgment. So that's the way this would come in.
Okay, so I'll go back to this. So there's two issues here. One is, was it finally litigated? I find if this is good law, assuming it's good law, this was fully litigated, that decision was decided. So the other issue you had is about the format of it. One.
Well, I have several issues, Your Honor, and I would ask the court for clarification. When you say this was finally litigated, what's this? Because
the issue of whether or not Delgado breaches fiduciary duty.
Okay. And but which facts within that? Because whether or not Mr. Delgado breached his fiduciary duty is not an element of anyone's claim here. It's not been pled that we breached the fiduciary duty because Mr. Delgado did. So that's not what they've pled in their claim for breach of fiduciary duty. They've pled specific.
Well, that's a separate issue. I'm
okay.
dealing with that first issue. So second issue is whether or not they pled this. So Mr. Ortiago, did you guys plead breach of fiduciary duty in this case, that Delgado breaches fiduciary duty?
Yeah, so the answer is yes, Your Honor. What we've alleged in both cases was the breach of fiduciary duty occurred with the mismanagement of FSG, the company. And so that allegation was duplicated from Delgado in this case as well. So that allegation is the same in both cases. And that our theory essentially is that, look, we won against Delgado regarding the mismanagement of the business. That same allegation is pending here. While it's more expansive, our claim is certainly more expansive against multiple defendants in this case. We should not be forced to relitigate that issue since we've already won on it in the Delgado case.
I'm looking at paragraphs 140A through E for their seventh amended petition, and they don't mention Mr. Delgado, period. In fact, the only thing that they have is failing to properly operate the company after terminating Mr. Holm, but they don't identify whom or what. And so when you do collateral estoppel, you have to give us fair notice. These are the facts we're seeking to say litigated.
So that allegation, of course, is the allegation against the current defendants, but that same allegation was lodged against Mr. Delgado personally in the Delgado case. That's why I'm saying it's overlapping. So the fact that we've prevailed on the allegation of mismanagement against Mr. Delgado means that we should not have to relitigate that issue in connection to that same mismanagement allegation lodged against the rest of the defendants. He was the CEO of FSG during the relevant time period.
Well, Mr. Ortiago, surely you're not saying that because Mr. Delgado breaches fiduciary duty that other individual defendants breach their fiduciary duty as well.
That is correct. We're not saying that. We've limited this motion purely to FSG, who Mr. Delgado was the CEO during the relevant time period. It's purely against FSG, not against the other individual defendants.
But it still doesn't help us, Your Honor, because, for example, one of their allegations in the Delgado case was he allowed his personal interests to prevail over those of Five Star Global, which suggests that he's acting in a capacity outside of it. That allegation is not repeated in here, nor do I know if that's the basis by which they're trying to have collateral estoppel for failing to properly operate the company after terminating Holm. And it's not just overlap, not just, hey, there's some similarity or there's some things that are similar. You have to identify the specific facts you're saying were fully litigated to their conclusion, so we know. This is a mixed fact and law determination the court says, which is why I say it can't be done in this summary disposition process. With respect to it. So what they haven't alleged in their claim is one of the elements of our claim is the application of collateral estoppel based upon what happened in the Delgado case, which would put us fairly on notice in their petition. You can't just show up and say, well, now that we've had this case and everything, I'd like to think some of these things are litigated, or conceptually the concept of his breach of fiduciary duty was litigated. That may be true, but then to use offensive collateral estoppel against different defendants, not the same party, but someone else.
They're only doing it against FSG. They're not doing it against other individual defendants. I agree with you that if they tried to say, you know, Bob Jones, who may be another individual defendant, you couldn't use collateral estoppel against him. But I mean, he was the CEO of the company.
It doesn't matter. That employment status is not the standard, Your Honor. The reason why is because then everyone would just sue the employee and then go after the company and say, sorry, it's too late. You have to show control. Control is the ability to control that person in connection with the litigation. I can control you in that litigation. Therefore, it's fair I should be bound by it. He didn't work for us at the time. We're not a party. We can't control him. There's a corporate indemnification, but the case law says even that's not enough. He had the same lawyers. Case law says even that's not enough. Your lawyers can't create collateral estoppel. You have to show that that entity controlled him in the lawsuit, controlled him in connection with that, not just generically that there's some connection or that he was the CEO on it. Because remember, you are binding a party not to that lawsuit. You're saying, well, it was your employee. It doesn't matter. You weren't a party there. You have to show that we had the ability to put on the same.
There's clearly privity, right?
No, disagree, Your Honor. Privity is different than employment status or relationship. There's not. For collateral estoppel, privity is different because you are binding us to a trial we weren't at. And that's really what's happening. You're eliminating our right to have that trial, period. And so if you're going to do that, you have to show that we can control the action, even if we're not parties to it. I can direct his defense. I can put on witnesses. I can tell his lawyers what to do for it, and that they could be his successor and interest in that case. And so you really have to show that element of control. And it's a misnomer to say, well, he was your CEO, because collateral estoppel would then be very easy. People would stop suing companies. They would sue the individuals and later say, well, you know, it's collateral estoppel. So that's the problem with this. Procedurally, I mean, you just literally can't do this. You can bring a summary judgment motion on it, but since they don't identify collateral estoppel as one of the parts of their claim, we wouldn't have had notice of it. Summary judgment deadline is passed. The court knows they've already moved for summary judgment. Court denied that with respect to it. So you're beyond how you can.
I denied summary judgment on this claim before.
No, Your Honor, but not on this specific issue, but they had the opportunity to bring summary judgment and did not bring it. Here's my point. You can't decide collateral estoppel in a summary disposition fashion. There's no procedural mechanism for it. People have tried to show up at pretrials. There's multiple cases we cited to you and said, oh, but apply collateral estoppel. And courts like here have said, yeah, I know, because I know about that case, I'll apply it. It's been reversed because that's not procedurally or evidentially how you do it. You have to do it through a summary judgment process, or in the bench trial, the court certainly can take and hear things and decide I'm going to apply collateral estoppel in connection with a particular claim or issue. You could certainly do it that way because you would have heard the evidence and we would have had opportunity to present that with it. What you can't do is on a motion based upon the pretrial rule, summarily dispose of what's essentially a mixed issue of fact and law. That's what the court can't do, because you got to hear about privity, what the court might make a factual determination on it. The court has to hear about the fairness issue, whether it's fair to this particular defendant that you would say you don't get a trial. I mean, the court's ruling for this would be extraordinary, which is you're telling a party, you didn't control that guy. I'm not even sure you guys even got along. You might have even been hostile, but I'm not going to let you have your own trial on this issue. And so it was the plaintiff's choice to have two different lawsuits. And I would encourage the court. I'm
sorry, I have to jump in on that. We've cited evidence in our motion that it was Global that opposed the consolidation of this, and we've attached that to our motion. I'm sorry, I tried to sit tight, but that's just factually inaccurate.
It doesn't matter. Listen, there's a whole history of how this got filed and removed and back remanded and all of that. And my only point is that on a 166G, where we're supposed to tell you what legal issues you can rule on in connection with the trial, is not the way this is resolved. It's just not.
Your Honor,
so if I could finish, guys, and then I promise I'll give you full reign to say whatever you want. But you've got, and then finally, you've got this issue of fundamental fairness. And if the court's going to apply Fifth Circuit when there's no Texas law case on this, I would encourage the court to read that, because the first element of that case is could they have been brought in the same case? Not did I file two separate cases and try and consolidate them, but were they possibly be brought in that case? And if so, you don't get offensive collateral estoppel. You don't get to be a plaintiff, file multiple cases, and then try and take the benefit of whichever case you think was the best for you. And I would ask the court to look at it. Now, look, the court can streamline the evidence on the Delgado issue if it so believes. The court can hear argument in connection with it, and whatever evidence is submitted, and decide it doesn't need to make fact findings regarding the Delgado issue, that it's going to apply collateral estoppel. That's typically, in my experience, how it's done in connection with it when you have multiple parties. But I don't think the court can take it now and say, yeah, it seems like it's the same thing. Why would I want to hear this twice at this procedural juncture? So that's my argument. I would ask the court that it can easily defer this issue. It's not going to shorten anything in terms of what the parties are considering or planning on doing, although efficiency isn't really the driving force here in this particular case. I really think it's more about fundamental fairness and whether, in light of that, you tried a case, vacated voluntarily your judgment, and now want to try and use the benefit of that judgment against another party does not fit within the realm of what would be typical use of collateral estoppel. Now, I thank you for letting me finish, guys. I certainly will yield the floor to you guys to respond.
Sure,
Yeah, Your Honor, I just wanted to hit a couple issues. One, from the procedural standpoint, which is whether or not Your Honor has the ability to even make a ruling under 166G. The answer is yes. I cited this in the motion, which was not actually responded to in the response by the defendant. It's a Texas Supreme Court case from 2018 called JP Morgan Chase v. Orca Assets. And what happened in that case is that, pursuant to 166G, during a pretrial conference, the trial court dismissed all of Orca's claims, including fraud, negligent misrepresentation, breach of contract, all of the mixed questions of fact and law that was being referenced by Mr. Tillotson in his remarks. And that order of dismissal was ultimately affirmed by the Texas Supreme Court, who found it was appropriate. And in fact, the trial court had the ability to make that ruling at the pretrial conference pursuant to 166G. Now, the other cases that was cited in the response are all older cases. I think some of them were from the 50s, maybe one of them were from the 80s. They were not dealing with, frankly, this specific issue. They are often dealing with under what procedure potentially should the other side be given under a summary disposition. And they were saying that, well, you have to at least give the other side notice so they can give controverting evidence in response to these sorts of issues. That happened here. So we filed a formal motion. We did not ambush anyone at a pretrial conference. They had more than 21 days to file controverting evidence. They did file some attachments to their response. So they were given a summary judgment-like proceeding related to the pretrial conference under 166G. So even under the more liberal standard, or at least the more conservative standard, depending on how you look at it, being articulated by these older cases cited by the defendants, they were given enough procedure and enough notice to allow the court to make this ruling. Ultimately, under 166G, Your Honor, it is really just for a judicial economy, which is, this is a pure legal question. Your Honor is going to have to make a ruling on this either today, tomorrow, or certainly before trial or during trial. It would make more sense to do it sooner rather than later, because it's going to streamline the presentation of the parties at trial to know if we're going to have to relitigate this specific issue or not. So it makes a lot of sense to make that ruling right now. Lastly, I want to hit on privity, Your Honor. The issue regarding privity, Texas Supreme Court says we're able to show privity if the other party, who is not a party to the underlying action, had control of the litigation. The Dallas Court of Appeals, in a case that was actually cited by the defendant, says that pretty much if there's an indemnity provision, such as an insurance company, there's almost always going to be privity. The only exception in that case is if there's a dispute regarding coverage, then there wouldn't be privity. Here, there was no dispute regarding coverage of the indemnity provision in the company agreement. Mr. Delgado was being represented openly pursuant to that indemnity provision by the same set of counsel who was representing FSG in this case at that particular time. They clearly had not only control of that litigation, but they had a seat at the table. In fact, Your Honor questioned whether or not there would not be a conflict because there was no responsible third parties being designated between FSG and Mr. Delgado. And the response back from counsel for FSG was that they did not perceive a conflict and that they did not designate, I guess, FSG as a responsible third party pursuant to their own reasons. Regardless, there's clear evidence and indication that there was privity pursuant to the Dallas Court of Appeals and Texas Supreme Court case law cited to by the plaintiffs in the motion and in the reply. So yes, there was privity, and yes,
this case out of the Texas Supreme Court about 166J motions, what were the facts of that? I mean, the judge dismissed the entire case.
Yes.
It's interesting. I've never really had anyone try to use this 166J until fairly recently, since COVID started. I've had it happen a couple of times. I just find it very hard to figure out, like, when it's just a very vaguely worded section, which I think is why it was so rarely used. Maybe it's being used now because of this Texas Supreme Court decision, but what were the facts of the Texas Supreme Court decision?
So the facts, the issues there was that Orca was suing based off of fraud, breach of contract, and negligent misrepresentation claims based off of the idea, the theory that they were misrepresented whether or not certain oil and gas leases were open and capable of being leased. And the trial court ultimately found that there could not be reasonable reliance based off of the allegations being alleged by Orca, and therefore dismissed all of those claims because there could not be reasonable reliance. And so, again, that is a mixed question of fact and law, and it went up on appeal, and the Texas Supreme Court ultimately affirmed that dismissal and found it was appropriate under 166G. And if need be, we can download that case and look through it, but that is the basic procedural history of that case.
May I just respond, Your Honor? That was a case from Judge Cortez, who dismissed it during the pretrial. The Dallas Court of Appeals affirmed the dismissal, saying that they either knew or had reasonable knowledge of red flags about the fraud, and then it was appealed up to the Supreme Court. The Supreme Court just simply recited the procedural history, saying the trial court dismissed it, Court of Appeals affirmed, and then they affirmed the Court of Appeals opinion, never really discussing the procedural part, discussing what is now the red flags defense you have in fraud. That's where that case came from. Baker Boss was on the other side. It's now a frequently cited case regarding, hey, you should have known that there was potential fraud. It does not address, nor does it rule on the propriety of a 166G dismissal. I remember following the case because it mattered for a lot of other cases. I don't recall why Judge Cortez dismissed it at the pretrial on it, but that's the procedural history of it. You can look at the opinion. They recite it, and then they start off with affirming the Court of Appeals on it. So it doesn't really give guidance, in my opinion, that you can summarily dispose of claims. I mean, Judge Cortez did it, and they didn't. No one seemed the court didn't seem to really address whether procedural you can or can't do that. They focused on the other stuff, if you will.
So the only thing I would add to that is that while it was not hotly contested whether or not the trial court could do it, the Texas Supreme Court does spend a couple paragraphs explaining the rule 166G and explaining why it was appropriate to dismiss claims pursuant to 166G. So there was some discussion about the rule, and it did affirm that it was an appropriate vehicle to dismiss claims on the merits at a pretrial conference, even if it was not a hotly contested issue in the appeal.
Essentially, if it's purely a question of law, I think, if this was just simply a question of law, like does Texas law apply or does it not? And if Alabama,
but, I mean, that other case couldn't have been just a question of law, right?
Well, I think they deemed it, I think, as a question of law. It couldn't have been a fact question because I don't think you could have supported dismissal on it. So they found as a matter of law in that case that the existence of certain red flags meant as a matter of law you could not justifiably rely.
Okay.
And they say that's the whole point of this case was they say, normally justifiable reliance is an issue of fact, but they said, and I'll quote you what they wrote, the element can be negated as a matter of law when circumstances exist under which reliance cannot be justified. So on a pure question of law, and I'll give you an example I have in another case. Does Texas law apply or does Louisiana law apply? If Louisiana law applies, our claims are clearly barred. If Texas law applies, our claims survive. Could that be decided on a 166G in terms of a question of law of applying Texas versus Louisiana law? Yeah, I think it probably could. on it. But when you have to litigate control and issues of fairness, like is this fair to the defendant, then I think you're into mixed fact and legal issues, which would preclude its disposition in this manner.
I wish I was more familiar with 166J motions. Are just so rare. I do think this is one that at least partially could be decided by summary judgment. All right, I'm going to go ahead. So what exactly are you asking for, Mr. Artiaga? You're asking me to grant say that there's collateral estoppel, and that I do think that there's probably a fact issue about whether or not there was privity. So I'm going to find there's collateral estoppel on the issue of whether or not Mr. Delgado committed a breach of fiduciary duty, the issue of whether or not he was in privity with and tell me if this makes sense, if whether or not he was in privity with FSG, I think is something that would be decided by the fact finder.
Okay.
Does that make sense?
It does. I will say, if Your Honor does find privity, that there was in fact privity at the time that Mr. Delgado, breached the fiduciary duties, that would essentially mean that FSG breached its fiduciary duty. We have proven our claim, at least in that respect. Is that accurate?
I'm not okay. What I'm saying is that Delgado, the issue, I don't want to relitigate the issue because it took quite a while, on whether or not Delgado breaches fiduciary duty. We can try the issue of whether or not Delgado was in privity under the law with FSG. That issue is still open and not been decided by collateral estoppel, because that's not something we litigated in the first case.
Okay.
That makes sense, Mr. Tillotson?
It does, Your Honor. I just would like to preserve, in whatever fashion I can, the argument that depending upon what that evidence is, it may or may not make collateral estoppel fair to this particular defendant. But that wouldn't entail any other evidence other than what we're going to do anyway. But
Okay.
That issue hasn't been decided either, whether the application of collateral estoppel is fair to this defendant.
Okay. I think it is fair to this defendant. So the only issue that will be litigated as to whether or not Delgado's breach of fiduciary duty should be ruled against or used against FSG would be whether or not there was privity. That's the only remaining issue on that. So, Mr. Artiaga, if you could prepare an order, if that makes sense, share it with Mr. Tillotson, and then we will make sure that it says at the beginning that this was heard on January 31st, 2022. And I would love to do your other hearing, but unfortunately we need to, or right now, do your other hearing. So we will need to get back to you once we rule on these other issues, other cases. So Yellowfin Loan Service versus Travis, is everyone here?
Yes, Your Honor, I believe so.
Okay. All right, let's go ahead. And who's here for the plaintiff on that?
Your Honor, that would be me, Craig Nowak, on behalf of Yellowfin Loan Servicing Corp.
And who's here for the defendant? Who's here for the defendant?
I believe it's Mr. Rossini, but I think his mute is still on.
Mr. Rossini, you're still muted. Okay, are you guys ready to get started?
I am, Your Honor.
Is Mr. Rossini, are you unmuted? The mute's on your bottom left, Mr. Rossini.
Or I think you can press and hold your space bar while you're talking.
Yeah, no, I had it. I was in the wrong place, so I have it now.
Okay. You guys want a record on this?
Yes, Your Honor.
Okay. If you could announce, Mr. Nowak, the case name and the cause number.
Yes, Your Honor. My name is Craig Nowak. I'm here on behalf of Yellowfin Loan Servicing Corp. Cause number versus John W. Travis. The cause number is DC 2017132.
And was there, I didn't see a response being filed to this. Was there a response filed to the motion to dismiss?
Yes, Your Honor. I filed today. I must have missed it somehow, but like Friday, I saw the motion and I did file a response today. I'm sorry it's late. I just didn't have I didn't have it really in my hand until Friday afternoon, and I did get it done today.
Is there an objection to this? I don't see the response in the system, but Mr. Nowak, are you objecting to the late filed?
Yes, Your Honor. I think for that and for another reason, there was, and it styled a motion to keep the counterclaim on the docket. And I saw that it was filed today. I don't know if it's been accepted by the court. The two main issues are timeliness, but also the fact that it's filed, not filed in the name of the defendant. It's filed in the name of Jing Peng, who is the named executor in the will. So this is a very interesting situation that we'll have to get into, but bottom line, yeah, I was planning to move to strike the response due to those issues.
All right, let's go ahead.
Yes, Your Honor. So this is a 91A motion to dismiss. This is a very straightforward case that the defendant was trying to make more complicated. It is a suit on a promissory note secured by, it was a second lien promissory note on a house. This is a money only suit. There is no attempt to foreclose on any real property. The reasons for that we can get into later, but realistically, and according to the pleadings, this is a suit for money only on an accelerated promissory note. The defendant filed on December 13th a first amended answer, counterclaim, and request for injunctive relief. And the gravamen, and on the same day, filed a notice of death, saying that the defendant died on December 12th. So this is critically important. Defendant died on December 12th. On December 13th, two documents were filed: a notice of death saying that he had died on the 12th, and then also the counterclaim. So the counterclaim, even though it's dated for the Friday before, was not filed with the court until after the defendant, by the filings of the court and the defendant's attorney's own admission, passed away. So this counterclaim, the substance of the counterclaim, is that they have asked for a declaratory judgment and injunction. And the declaratory injunction is that the Yellowfin as a successor in interest to the original lender should not have its lien, and they should get clear title. The main legal argument on this case is that you cannot do that with a declaratory judgment action. So there are a number of procedural issues with this, right? The first is, if the defendant died before the counterclaim was filed, was it actually allowed to be filed? The second is that the response, the motion that was filed today, which was filed in the name of somebody who claims to be the executor in the will, but there's no personal representative established. There's been no substitution of the estate. Does that have any effect? Clearly, it wasn't timely filed, but I would argue there's no standing or capacity for Mr. Rossini to have filed it on some third party who hasn't been authorized by a probate court. But when you get to the actual substance of the motion itself, it's very, very easy. I cite to the case law in the motion that says you cannot use a declaratory judgment to decide title. That is a trespass to try title suit. And I cite the Ramsey versus Grizzle case, which has a laundry list, and I'm happy to share the screen and go through.
I know the law on this.
So you can't do what defendant or at least counsel for defendant is trying to do in this case. And that's the legal basis for the motion to dismiss. I'd also add that there's no basis for the counterclaim on the facts. So if you read through the counterclaim, the defendant admits to signing the lien, the note and deed of trust, and simply says because he hasn't paid on it for so long and nobody asked for the money, that the lien somehow disappears. There's no there's no legal basis. There's no legal argument for that. The lien survives unless it's extinguished or paid, but that would be the subject of a trespass to try title suit. So even under the facts alleged, even if you said, well, we'll allow the Declaratory Judgment Act to function as some kind of vehicle for this, under the facts that they've given, where they admit that they voluntarily granted a lien on the property, there's no set of facts that they've alleged that supports their cause of action. And again, my biggest struggle right here is there's no standing or capacity of whatever entity Mr. Rossini represents at the time that the counterclaims were filed. So I'd argue that the counterclaim was improperly filed post-death, and it shouldn't even be considered by the court because it was never filed by the defendant. The defendant could have had a change of heart, decided to settle the case, on the 13th before the filing occurred. We'll never know, but if you pass away on Sunday, the lawyer can't on Monday file stuff like you're still alive. So that's my motion in brief.
Response?
Yes, Judge. For one, to say that the counterclaim doesn't have any merit factually, there's no evidence of that. My client didn't admit that, hasn't let himself out of the case. In terms of my client being deceased, I filed, as far as I know, I filed the counterclaim while my client was alive. Now, he passed away shortly thereafter, but he didn't. I don't think that would be, I really don't think that would be something a member of the State Bar of Texas would do, would be to file a lawsuit on somebody that isn't alive. Because that basically you're filing a lawsuit for someone that isn't there, that will there be no standing. As to the idea of, it's true that the case, partially at least, has a slander of title case, but it's also asking the court as a declaratory judgment to determine that the behavior of Yellowfin is actionable. And what Yellowfin has done is Yellowfin has filed a lawsuit against my client, and they're clearly the successor in interest to somebody. I mean, they're not the original lender. They filed a case only on an unsecured basis. But there is a lien on my client's property, or my client's deceased client's property. Well, there shouldn't be a lien on property when Yellowfin is making no effort to collect and will make no. So just in perpetuity, there's a problem with my client's title, and that shouldn't be. There should be some resolution of that. As to the individual that's, I can't file, as has been, very kind of adroitly noted, I can't file a lawsuit for someone, unfortunately, who's passed away, and it hasn't been that long. The individual that I'm representing is the son, and he doesn't have executory letters yet, or letters executory, but he is, as far as I know, he's attempting to do that. So to keep the case open long enough for him to get letters executory and then move forward, I think makes sense. Without making any determination, a motion to dismiss is based upon facts or law that are conclusive, and they're just not conclusive in this case. They're to be determined.
All right, thank you. I'm going to, given the procedural status of the case and the issues that have been identified, I'm going to go ahead and grant the motion to dismiss the counterclaim. That doesn't mean that at some point you could file a counterclaim in the correct format with the correct party, but the counterclaim as it is right now is going to be dismissed. I don't find that there's any ill will here or anything like that. And so I don't typically like to award attorney's fees unless I feel there's some kind of abuse. And so now that I have discretion to do that in a 91A motion, I'm going to go ahead and deny any request for attorney's fees. I think you've already submitted your order, Mr. Nowak. Is that correct?
Yes, Your Honor.
I will try to get that entered today. You guys, you be safe, and I hope you guys good luck with everything. Thank you so much.
Thank you, Your Honor.
Thank you, Judge.
Mr. Cricket, I think you're up next.
Yes, Your Honor.
I think you just filed
It's an amended pleading, Judge. The original petition was filed by a different lawyer, and I entered an appearance in December of last month, and I can get into the substance of the amended pleading and the motion that we're presenting today, or the request for temporary restraining order, if you're ready.
Go ahead.
Okay. I represent Marvel Investments and Angelos Kolobotos. They are the movants in this matter. We're seeking a temporary restraining order on multiple bases, primarily on the issue of accounting. There are some secondary bases upon which we're seeking a TRO that deal with notice and conditions precedent. But as it pertains to the accounting, if you'll look at pages 4 through 6 of the document that I filed today, I specifically set forth payments that were tendered by my client and either not credited, were cashed but not credited. Then there's a second group of checks that were tendered to the defendant that were held. They were not cashed, but they were not returned. And then at the top of page 6, there was actually a payment that was made in October of last year, and it was cashed probably in early November. And one of the contentions for the TRO is that when the defendant cashed that check, that constituted an abandonment of the acceleration. And therefore, they would have to, do a new notice of default, opportunity to cure, and a re-acceleration of the loan. But the bigger concern here for my client, Judge, is that since I got involved at the end of December, I've reached out to the defendant's counsel on 5 different occasions seeking an accounting. The first time I contacted them was via email on December 30th, requesting an accounting, explaining to them that my client disputes the accuracy. I sent a renewed request via email on January 21st. That was not responded to. I sent a third request for a payoff on January 24th. That was not responded to. And then last week on January 26th, I finally sent a formal debt dispute, and I provided some substance behind the dispute. And that correspondence is attached as Exhibit F to the pleading in front of His Honor. And you can see in the response that I finally received back from the defendant's counsel is they're saying, essentially, you've got the accounting. We're not sending you anything else. Beyond the scope of this pleading, I do make mention, my client has procured an independent source to pay off this loan. That lender cannot do anything unless it gets the information that I've been seeking for a month. And this property is my client's homestead. There's more than $100,000 worth of equity in it. We're prepared to pay off the defendant what is owed.
So,
but
Mr.
Cricket,
let me just tell you what my concern is here. So previously there was a TRO granted in this case, correct?
Yes.
And that TRO, I guess, lapsed.
My understanding is that the lawyer representing the plaintiffs at that time did not schedule it for a temporary injunction hearing.
And then you're seeking a new TRO, correct?
Seeking a new TRO, we were seeking to pay off the loan, but we're not getting the loan payoff information that we need to pay off the loan.
Okay.
And so without getting that information, my client's not in a position to pay off the loan, to discharge the debt.
Is there anyone else here on that case today?
I just want to jump in. May I ask who the defendant is? Because Mr. Cricken has been emailing me today strikingly similar facts. And I just want to know if it's the same property. I happen to be in the Zoom courtroom at this time.
Thomas Holiday and Angelos Kolobotos.
Who's the defendant?
Thomas Holiday and Angelos Kolobotos.
Okay, sorry, Mr. Cricken, it sounded like what you'd been emailing me about separately, but I will
Fair
I will
enough.
stand
Fair
down.
enough. No,
I sent you the
understand.
payoff you requested. I'll
Yes,
I'll
yes,
shut up
ma'am.
now.
No worries.
Is that the same case, Mr. Cricken?
No, it's a different case, Judge.
Okay. It's weird you had the same issue in both cases, but
Well, this is a new client to me, and he does have several properties that went into default when he was not collecting rents during the pandemic. He filed a host of bankruptcies, which necessarily frustrated a lot of lenders. But on this particular case, he has been tendering monthly payments. The amount of the default is certainly in question. It probably is, in the neighborhood of, well, my client thinks he's not in default. The defendant, we don't have an updated accounting, so I don't know what the defendant is providing. The last accounting that I received is attached to a brief in opposition that was filed by the defendants in this case in September, and that accounting goes through May of 2021.
so the issue I have, let me just cut to the chase. The issue I have is that there's case law out there that you can't just grant TRO after TRO after TRO, that this would need to be done in the form of a temporary injunction, but I'm not even sure if that's really the right procedural mechanism, what you want. What would help you get to where you want to be? I don't know that it's a TRO. They're not trying to foreclose right now, right?
No, they are, Judge. There's a foreclosure scheduled for tomorrow. So on the one hand, they're not providing us with the information necessary for us to discharge this debt. And on the other hand, they're moving forward with foreclosure on a property that has a substantial amount of equity in it.
Okay, well, I guess why did your client wait until today to deal with this?
Judge, I suppose I could have filed something last week, but I was hopeful that the defendants would provide a statement or a payoff amount.
Do you see what my concern is, though, that if you just file TRO after TRO after TRO, then you never get to the injunction phase, that it's unfair to the defendant because they don't get the due process you get with the temporary injunctions?
Sure. I did explain, as noted in the correspondence, that in the that this is a bona fide accounting dispute, that there is a discrepancy in what they are proffering, which actually is 10 months stale. I don't have an updated figure. They're not providing it to me. And they, there's apparently no incentive for them to be here today to, provide the numbers that my client needs. If my client was to show up tomorrow with a foreclosure sale with a bag of money, we don't even know what the amount would be.
Can you share is that attached to your petition, all of because this was just scheduled today. So was there anything?
Sure. I would direct the court's attention to pages 4, 5, and 6 of the pleading, and then also to Exhibit F, which deals with my correspondence to the opposing counsel on this matter.
There is an opposing counsel. There's not one listed here. Is it opposing counsel in this case or just opposing counsel that represents these folks?
There's 2 lawyers on this. Chris Snyder filed a brief in opposition to the original temporary restraining order that was filed back in September 2021. But Gary Sibley appears on the pleadings as well. The correspondence that I have through email is with both Chris Snyder and Gary Sibley. Gary Sibley is the person who responded back saying, your client has the accounting. If you dispute it, the ball is in your court. So it's kind of a snub to a reasonable request for information made in good faith.
Give me 1 second. All right. What I'm going to do on this is I'm going to the foreclosure sales tomorrow afternoon, right?
I believe it's scheduled for 10 a.m., Your Honor.
Okay. And did you put them on notice of this hearing, Mr. Sibley? And
I did.
Rhonda? So the TRO that was set for today, go ahead and notify the defendants in that case. There's a Mr. Sibley. Mr. Cricken is going to call you and give you the information, but it's also attached to their petition. There's a Mr. Sibley and another attorney. Email both of them. Tell them that they need to be here for the TRO tomorrow morning at 9. And let Mr. Cricken know that we're going to have a TRO at 9 as well. Zoom, yes. And if you can't find Mr. Sibley's email address, call Mr. Cricket. Thanks, bye. Mr. Cricket, we'll see you tomorrow morning at 9.
Is that in person or did I catch that that's by Zoom?
Zoom.
Zoom. Okay, very good. Thank you, Judge, for your time.
No problem. Bye-bye.
Bye.
All right, is everyone here for the prove up?
Your Honor, Steve Easton from Lynn Tucker. For the plaintiff, I'm here. I don't know about the others.
Gabrielle Mathis, judge on behalf of the defense. I am filling in for Ms. Hodge this afternoon.
Is the guardian ad litem here? Who's the guardian ad litem in this case?
Melody Armstrong.
Melody Armstrong.
Okay, and she was here this morning on another case. Miss Armstrong, can someone call Miss Armstrong?
Once, Judge, it looks like she just emailed me. Oh, she did not have the link. I am forwarding her the link right now, Judge.
It's the same link she had this morning, so that's okay. She may not know that.
Link to the link.
All right, well, let's go ahead and go forward then with the motion to exclude in the Hume case, DC 208643, Mark Hume versus 5 Star Global. Counsel, make your appearances.
Lee Pettit and David Urtiago on behalf of the plaintiff, Your Honor.
Jeff Tillotson, Austin Arabali on behalf of the all the defendants but Southfield.
Katrina East here on behalf of Southfield.
All right, we're hearing a motion to exclude. Let's proceed.
May I share screen, Your Honor?
You may.
Hopefully you can see my screen. Your Honor, the short version behind what we are arguing about today is whether or not a URL equals the emails that go along with it.
Okay, I've read all of this and I don't have a ton of time. So,
Okay.
the issue seems to be that they're claiming that they purchased these emails.
Yes, Your Honor. So I will
So
be
let's get to that point.
possibly can. So what they purchased, Your Honor, and I'll show you in the APA here in a moment, is a URL. I'm using my law firm's website as an example so you can see. So they purchased a URL. They didn't purchase emails. What their argument is that because they own a URL, if it was my law firm, for example, and I were to sell my URL to someone after I retire, then that person who bought my URL would somehow have also acquired my 20 or 30 or 40 years of historical emails that go along with that when I merely sold my URL. So let's look at what FSG purchased. When you look at what FSG purchased in the APA, it says they purchased intellectual property, and it says section 411A of the disclosure schedules lists all intellectual property registrations and intellectual property assets. When you look at what they purchased, which right here is schedule 411A, I've highlighted, they purchased URLs. They did not purchase email accounts. There were multiple lawyers all over this transaction on behalf of both parties. If they had wanted to purchase historical emails, Your Honor, that would have been included in the contract, and it wasn't. There were also excluded assets. The individual that owned all of the company at the time has a number of other brands, and those things were specifically carved out. Things like the National Fantasy Football Convention, the Jobs film, Hugo's Invitados, things like that. The way that the email account was set up is there is a master Google account where you can have a number of different email domains that go along with it. So there's one master account. You could send emails from that account, from that Google account, from DS News, from 5-Star Conference, from Hugo's Invitados, from NFFC. So you can send different emails through this same Google account. Importantly, of course, some of those were not transferred because they were excluded assets, like the Hugo's brand was not transferred, NFFC was not transferred. So 5 Points Holdings couldn't have possibly sold this Google account anyways to 5-Star Global because it contains other brands. What happened, Your Honor, and it's important to note that the evidence that we attached to our motion to exclude has been uncontroverted. They apparently do not disagree with our story about what happened with these email accounts because there is nothing to controvert the privilege that we've asserted. So Mr. Tillotson's clients came to take over the company. They were just simply not prepared to take over the company. They didn't have bank accounts. They didn't have a way to host emails. And so my client, as a courtesy to them, said, we'll temporarily give you rights to this Google account so that we don't shut down business when you guys come in. We attached emails, Your Honor, from my client to Mr. Tillotson's client confirming that. So this is my client's email back in 2019 that says, we're talking about the Google email websites. And my client says to his client, did FSG get their own Google account and email? The current Google account belongs to FPH and only the domain names belong to FSG. There needed to be a new account set up and then the domains names transferred. Mr. Hobgood, who works for his
Well, go
client,
back one. It says if the emails for current employees can't be easily migrated, then we can just get access to them until no longer needed.
Correct. So my client, the affidavit shows we were doing it as a courtesy because the equity group that was coming in just didn't have.
But don't you represent FSG, right?
No. I represent FPH.
FPH. Sorry, you represent FPH.
Yes.
Well, why would the FPA? So why would FSG's employees need to be why would their emails need to be migrated?
Sure, because the employees that used to work for 5 Points Holdings, so like let's go back here, the employees that used to work for DS News and 5-Star Conference, those employees were part of the transfer. And so the employees themselves used to work for 5 Points Holdings. Now they work for 5-Star Global. 5-Star Global had no IT infrastructure set up. So 5 Points Holdings said, we'll let you use ours until you guys get your IT infrastructure set up because they were not set up. So, and that's the Harrison affidavit tracks that, which is we temporarily told them you can use our IT infrastructure, but you need to get your own. And we attached email after email after email where our client is saying, you guys need to get your IT stuff set up. So the email that I just showed you, 5-Star Global responded, their CFO responded and said, Google email websites, this actually has been a conversation topic today. Timely question, this has not been completed. Your Honor, everyone acknowledged back when the parties were still on good terms, everybody acknowledged that this was my client's Google account that we were simply letting them use until they had an IT infrastructure set up. Mr. Harrison goes on in his affidavit, and as Your Honor is well aware, in early 2019, there's a big fallout regarding this AMAA transaction. That fallout happens in January of 2019. In March, 5 Star Global, the other side, not my client, 5 Star Global locks my client out of our own Google account that contains emails, not just for the assets and the URLs that they bought, but everything else. So that's when my client gets locked out. We have been dealing with this issue ad nauseum, Your Honor, since it happened in 2019. We've pled this issue since 2020. And the reason why it's coming up now is really important. Because prior counsel told us over and over, and here's a letter from them in 2020, which is why we hadn't brought it up during this time. They told me my concern was the privilege. Our motion for today, Your Honor, I'm just dealing with the privilege issues. I don't think they have a right to everything else, but certainly, Your Honor, in their possession, they have emails between me and my client about this lawsuit, and they're all in their possession. Now, prior counsel had assured us in writing that all of the privileged emails were quarantined. So when we were told they were quarantined, there's the transactional lawyer for this deal that negotiated the APA is Mr. McCullough. When we were told they were quarantined, I was like, well, let's stand down. I don't want to make I don't think they have a right to any of them, but mainly the privileged ones all stand down. So that was in 2020 that we were informed that anything with my firm and Mr. McCullough's firm was quarantined and not going to be used. Well, fast forward to the summary judgment hearing that we were talking about earlier, and which summary judgment that we filed was denied. And I'm purposefully, Your Honor, not putting the emails up here because I don't want to risk a waiver argument. But Your Honor, they attached page after page after page of communications between Mr. McCullough, the attorney that negotiated this APA that's in question in your case, and my client. So the actual emails between my client and his lawyer discussing the interpretation of the APA, they attached in response to their summary judgment motion. That's why this issue has come up and is so, so critical, because they've got the very emails with my client's lawyer regarding this exact thing that Your Honor is going to be asked to decide. Your Honor, as we showed, my client owns these emails, have always owned these emails. The other side has acknowledged in writings that we've attached to this motion that my client owns these emails. And if they're going to be moving forward at trial with documents that are between my client and either myself or his transactional lawyer that negotiated the dispute that's in question, we're asking for protection from that. So, Your Honor, there hasn't been a waiver. I'll cover that very briefly, but this simply doesn't fit within waiver because we never voluntarily disclosed or consented to disclosure. Mr. Harrison's uncontroverted affidavit establishes that. And so what's important, Your Honors, we've moved for a protection by privilege. We've raised evidence of all of the elements of privilege, and those have not been controverted by the other side. The test in Texas, if Your Honor agrees that we own the emails, then I think that kind of ends the inquiry and they shouldn't be used. But in any event, I will go on, which is reasonable.
Let me just hear from, we don't have a lot of time on this, and I really need to get to this prove up. Is everyone here for the prove up?
I think so, Judge. We were sharing the link just a second ago, but I'll make sure that everyone is.
Is everyone here? I think everyone, is the plaintiff here?
Steve Eason and Glenn Tucker's office. I don't see them yet.
Actual plaintiff, they're here because
And Ms. Jennings. Okay. So yeah, perhaps Mr. Tucker's office can get in touch with Ms. Jennings.
She's not here.
I don't see her.
Your Honor, we're both here in my office.
Okay. We're going to take care of the prove up right now because I'm kind of tight for time today, unfortunately.
Yes,
so we're going to take care of the prove up. If we can get to hearing number 37 in this case, then I'll try to, but I will say that anything that's privileged, I can't imagine a situation, I'll hear argument on this, that anything that's privileged, privileged communications are supposed to be quarantined shouldn't be used if it was. And so, but we can talk more about that if we can get to this hearing today. So let me deal with the prove up right now, guys.
Sure, Your Honor.
I have to step to the back of the courtroom. All right. Tony, let's go on the record for the prove up on cause number DC 191800. Jennings v. Gonzalez. Council, make your appearances.
Steve Eason on behalf of the plaintiff, Chiquina Jennings, on behalf of her daughters.
Gabrielle Mathis, Your Honor, on behalf of the defendant, Myra Gonzalez.
Melody Armstrong, guardian ad litem for minor plaintiffs TH and TJ.
All right, let's proceed. Call your first witness.
Yes, Your Honor, we call Chiquina Jennings.
Yes.
Ms. Jennings, please raise your right hand. Do you swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes.
You need to speak up a little bit because you're a little quiet.
Yes.
You can keep your mask on, but just speak up, okay? You may proceed.
Ms. Jennings, if you could state your name for the court for us, please.
Chiquina Monique Jennings.
Ms. Jennings, you're the natural mother of TH and TJ, who are the minors in this case.
Yes.
And TH was 9 at the time of this accident,
Yes.
and TJ was 4 at the time of this accident.
Yes.
And this arises from a car automobile collision on September 7, 2018,
Yes.
and with Ms. Myra Gonzalez, correct?
Yes.
All right. And as a result, that collision with Ms. Gonzalez, both you and your children suffered injury, correct?
Yes.
All right. This is brought into a lawsuit, and we have reached a settlement, correct?
Yes.
Okay. Now, part of your complaints was basically your neck, your mid-low back, headache, left shoulder, left elbow, and your entire back, correct?
Yes.
So you had a pretty, your injuries are pretty severe, correct?
Yes.
Okay. Now with your daughters, let's talk about TH. She was your front seated passenger, correct? Page 2. TH.
Okay.
TH was your front seated passenger?
Yes.
And as a result, she had headaches, neck and upper back pain and mid-low back pain, correct?
Yes. Yes.
And you had taken her to Baylor Scott and White, and also to accident and injury chiropractic for her injuries, correct?
Yes.
And the total amount of her medical bills was $1,854.51, correct?
Yes. Yes.
Now with TJ, she was of course seated in the back seat, right?
Yes.
And her complaints was her neck and mid and back pain, correct?
Yes.
And also you took her to Baylor Scott and White Lake Point, and also accident and injury chiropractic, correct?
Yes.
And her total medicals are $2,081.31, correct?
Yes.
As I've indicated, we've entered into an agreement, and it's outlined into the agreed judgment involving minor.
Yes.
For TH, we settled for $4,621.31, correct?
Yes.
And of that, $2,140.32 are for attorney fees, case expenses, and medical expenses for TH, correct?
Yes.
And $48.79 is going to be paid back to Medicaid, correct?
Yes.
And of that, the amount to be remaining is $2,139.89, correct?
Yes.
Now for TJ, her total settlement was $4,382.36, correct?
Yes.
And of that, $2,090.52 are for attorney fees, case expenses, and medical expenses for her, correct?
Yes.
And for her, $87.56 is to be paid back to Medicaid, correct?
Yes.
And the amount remaining from there is $2,203.92, correct?
Yes. Yes.
Now, you understand that the settlement that we reached a settlement, and I've discussed it with you, correct?
Yes.
And you understand you could have gone to continue with the case and gone to trial and either receive more or receive less or nothing at all, correct?
Yes.
Also, the settlement is for all the claims that the girls have now or could have in the future, correct? You understand that?
Yes.
And anything else that for medical bills that you're responsible for, you understand that?
Yes.
As a parent, okay. Since your understanding, the girls have reached their maximum medical improvement, like the best they're going to be for their injuries?
Yes.
Okay. And you've had a chance to discuss the girls' injuries with guardian ad litem?
Yes. I did.
Now, you agree to the amounts that were stated in the judgment, correct?
Yes.
You agree to those amounts? And you believe it to be in the best interest of your daughters for these settlement amounts, correct?
Yes.
Now, you understand that the way this is set up, that the money that are to be allotted to the children are going to go into the registry of the court, correct?
Yes.
And you understand that they can apply for the release of the money when they each turn 18 and present valid identification, correct? You understand that?
Yes.
Okay. But you understand that although the money is to be deposited into the registry of the court, that you're requesting that the money not be placed into the registry, but be given to you, correct?
Yes.
You're doing for a couple of reasons. One, for the de minimis amount of the girls' recovery, correct?
Correct. Yes.
And you would apply that amount to the girls' benefit, correct?
Yes.
And also, if you would just briefly explain some other reasons why you would like to have the money for the benefit of the girls and not into the court.
Of course.
Be sure to spell it out.
Oh, let me just take this out. Sorry about that. Right now, you know, I just got something like in the mail today. I got an eviction notice today. And it would also be just very beneficial to get the money, because if not, the girls won't have a place to stay. And I don't know what's gonna happen next, really, after today.
And also your girls involved, one of your girls is involved in track, correct?
Oh, yeah, both of my girls are in sports.
And the location you're at, they're requiring the parents to provide uniforms.
Oh,
correct?
yes. We have to pay for everything out of pocket for the girls' sports and everything else that they need dealing with their school, so.
All right, and briefly, if you would tell the judge, what is it you do for a living?
Right now, I'm unemployed right now.
You were running a salon, correct?
Oh, yeah, that was before COVID, yes.
Okay.
Mhm.
And as a result of that, business is way down.
Oh, yeah, because I had to take my business home, and ever since then, it's just no customers.
Okay. And you would like the judge to let you have the money rather than put it to the registry of the court?
Correct, yes.
Okay. But you understand that whatever the judge ruled, it's for the best interest of the girls that this happened, correct?
Yes.
Okay. Thank you. Pass the witness.
Ms. Mathis?
I believe I just have a few follow-up questions, Judge. Ms. Jennings, you were able to speak to the guardian ad litem regarding this case, correct?
Yes.
And for purposes of the settlement, I believe that your attorney asked you, but I just want to confirm that you are willing to forego a jury trial for purposes of the settlement, correct?
Yes.
And the total amount for your daughter with initials TH is $4,621.31.
Yes.
And for your other daughter with initials TJ is $4,382.36.
Yes.
And you understand that if either of your daughters requires additional medical care, the defendant is not responsible for such care.
Yes.
And this is the total amount of money that you're going to be able to collect from the defendant. Are you aware of that?
Yes, ma'am.
No further questions, Judge.
Mr. Armstrong, do you have any questions?
Yes, may I proceed, Your Honor?
You may.
Good afternoon, Mr. Eason and Ms. Jennings. Judge, the guardian ad litem report is on file for you if you want to peruse that.
I have looked at it.
Okay. All right, Ms. Jennings, we've had an opportunity to visit by video, myself and you and your daughters, correct?
Yes.
And I had an opportunity to visit with both of them about this crash and how they're doing today.
Yes.
And you are satisfied that your daughters have healed 100% from this particular crash?
Yes.
Okay, they are doing everything now that you've expect them to do, and they're really doing well in school. I saw their grades, so congratulations to you and them for that. Is that correct?
Yes, thank you.
All right. I want to confirm for us and for the court that you did not have any personal injury protection coverage on the vehicle that you were traveling in that day.
No,
And when we visited, we discussed the allocations, and that my recommendation, unfortunately, would not be that funds would go to you, but that I have to recommend that the funds be deposited into the names of each of your children for their benefits for when they're age 18. Do you understand that? Not that you agree with it, but do you understand it?
yes,
You also understand that if Judge Hoffman orders that the funds be deposited into the registry of the court, that they will remain there and they'll gain a little bit of interest, and they'll be released to your daughters when they turn age 18. Do you understand that?
yes,
And that the registry of the court is allowed to take a small administrative fee out of the interest that is earned under the local government code. Do you understand that?
yes,
Any questions about that?
no,
Okay. And you had your own settlement, I believe, for $15,000 as a result of this crash, correct?
yes,
Okay. You understand that if the court approves this settlement, much like in your own settlement, you're not able to come back and sue the defendants ever again. Do you understand that?
yes,
And are you asking Judge Hoffman to approve this settlement because you do believe that it is in the best interest of your children?
yes, ma'am.
Do you have any questions for me or for Judge Hoffman about any portion of this settlement?
No, ma'am.
And have I represented your daughters in this case to your satisfaction?
Yes, thank you, yes.
Pass the witness, Judge.
No further witnesses, Your Honor.
Is there a recommendation of the guardian ad litem in this case?
Yes, Your Honor. After being appointed by Your Honor, I had an opportunity to review the pleadings and the records and all of the claimants and all of the settlements in this case, as well as the limits available in the policies that were applicable to this case. And I had an opportunity to interview the children. It's your ad litem's recommendation that the settlement be approved in the amounts before you. The children, fortunately, are doing well. We spent some time to make sure that we had all of the medical records, Judge, and we even sent a request. I personally faxed a request to one of the primary care physicians, Dr. Vivian Menchaca, to make sure that there weren't any well child visit complaints where the children were still complaining about this crash. So it appears that each of the well child visits subsequent to this crash, there have been no complaints and the children appear to be doing well. So it is your ad litem's recommendation that the settlement be approved in the amounts before you, the allocations before you. I defer to the court for anything outside of the money being deposited into an interest-bearing account for the benefit of the two children.
But it's your recommendation that the money be deposited in the registry of the court?
It is, Your Honor.
Okay. And I will say, Ms. Armstrong, I can't even imagine how many at this point. Probably, I've been on the bench for 15 years, over 500 at least of these, if not more, and then probably close to 100 in private practice. I've never seen a judge, and I've never approved a distribution where the parents get the money and not the minors, because it is the minors' money. So I think you're doing what's exactly in line with what the law is and what's appropriate. But so I will follow the guardian line. Do you have any questions before I do that? Do you have any questions for me, Ms. Jennings?
Yes, I do, because number one, I am a single mother. Number two is just me and the girls. Everything I do is for them. And right now with the economy and my profession, it's just hard right now. And it would be the benefit for the children 100% if I was to get the money for the kids.
And I understand that. And I'm sorry that, this is a tough time for everybody with COVID and everything else going on. I understand that. But under Texas law, this money is the children's money, and the only way to preserve that it's the children's money is that we need to protect it until they turn the age of majority. So when they turn 18, if they decide they want to share the money or help you with your rent or whatever, that's their decision. But until they turn 18, I'm going to protect the children's money and so they can make the decision on their own. But I appreciate, Ms. Jennings, your concerns, and I do sympathize with them. But given the situation and given Texas law, I'm going to have to follow the guardian ad litem's recommendation. But thank you, Ms. Jennings. All right. Is there a agreement as to the amount of the guardian ad litem's fees?
Ms. Gabrielle, did Caitlin mention that there was any opposition? It's 3937.50.
She did not, and I don't have any notes about that. And that is what is in the judgment that I reviewed.
Okay.
So I don't believe there's any opposition. And from what I've been involved with, I think that that's fair for the two minor plaintiffs. So
Thank you,
So
Counsel.
we're good to go.
So I was looking at the file. So the guardian ad litem fees will be $3,937.50. Is that correct?
Yes, Judge.
And
Yes,
then
sir, that's my
I did
understanding.
not see that a judgment has been filed. Has there been one? I haven't seen it.
I think we finally got the final version of it done. I think we just need to insert the allotted fees and we'll just upload it to the.
Judge, we'll have it to you before 4:30. Not that you'll look at it, but we'll have it to you.
I'll do my best. I'll do
We
my best. But it
understand.
usually doesn't get to me quite that quickly. So the court will approve the settlement as requested by the guardian ad litem. Ms. Jennings, I wish you and your family the very best of luck. I don't want to keep you here any longer than we need to. So you guys are excused. Thank you so much. Thank you
Thank you,
again for your
Judge.
service, Ms.
Your Honor.
Armstrong.
Thank you. Have a good afternoon, everyone.
You too. Okay. Is there everyone here on the 4 o'clock motion to dismiss? Is everyone here for that? I'm sorry. I guess that's been canceled. Okay. All right, we can go back to the Hume case again. Tony, you ready to go back on the record?
Yes, Judge.
All right, we're going back to DC 208643. Ms. Pettit, were you done with your PowerPoint?
No, but I will be fast. May I share screen again?
You may.
Thank you. So just briefly, Your Honor, the 5-Star Global argues about employee handbook and there being a company policy about no expectation of privacy or so on and so forth. However, the law in Texas was there an intent for the documents to be made private? And so I'll again point to the Harrison Affidavit, which is uncontroverted, first of all, 5 Points Holding is an entity. The emails belong to the entity. So the entity didn't sign any sort of employee handbook agreement or anything like that. 5 Points Holdings expected that its emails that it sent and received to its attorneys on their Google account regarding this litigation would be kept confidential. So what I'd like to do is focus just briefly on what it is that we're asking the court for. It's our understanding from prior counsel that there were 2 million emails that were pulled from the Google account. I don't think it makes sense at this point for us to go and review 2 million emails for privilege. And so I think the way that we could streamline this is what we've outlined in our response, which is there is a certain category of documents that we know that they obviously intend to use that are communications between my client and their counsel about the APA. Those are the 2 exhibits that were attached to their summary judgment response, so that we would ask that those 2 be excluded. The base numbers of those are up on the screen. We subsequently went through the documents that they've produced. We've attached a log as exhibit A6. Those are the ones that are directly to the attorney from my client, and it's a 6-page log. So we know for sure that those are emails to the attorney that negotiated the APA about the APA, and Mr. Harrison's affidavit proves up the privilege of those. So we would ask that those be excluded. And then moving forward, what we ask for, Your Honor, is that on a case-by-case basis, Your Honor, consider, so for example, if they submit an exhibit list and it's got a bunch of emails with me and my client, or with Mr. McCullough and my client, we would ask that our privilege objection be preserved so that we could make it at that point in time, so that no one is required to review 2 million emails for privilege at this point in time. While we've isolated these few, there are certainly going to be ones that aren't caught because it might be my 2 clients, for example, conveying attorney-client privileged information or advice of counsel to one another that would be protected, that we simply don't get flagged when we run a search for Mr. McCullough's email or for my email. The last argument, or the argument put forth by the defendant, is that some of this would be within the scope of discovery. But I want to be really clear, because when I read the other side's response, I feel like I was confused. Maybe they didn't understand what we were seeking. But just to be clear, we're only, for purposes of this, seeking to exclude the documents that are privileged. I understand that they've gone through years and years and years of Mr. Holmes and Mr. Harrison's email. I dispute that. I think we can deal with that at trial. But for right now, all that we've moved on, Your Honor, is the privileged documents with me or with Mr. McCullough or any other counsel that I've forgotten. But there is nothing that is privileged that could have been discoverable. So with that, I'll answer any questions if you have any, but we ask that our procedure outline be.
Can you put up PowerPoint number 20?
Yes.
Okay. Mr. Tillotson, are you there?
I am, Your Honor.
So surely you're not trying to argue that privileged documents, that they've somehow waived their privilege here.
Unfortunately, Your Honor, I am. I mean, I'll tell you why. I mean, we're not being aggressive, but these emails. So there's 2 buckets of emails. There's
Right.
the emails that they sent back and forth in their entity, and we buy those domain names. And we now own the domain names. The main one is DSN News. Now they're with the new entity, employees, and they're sending emails now, new emails. Those emails are being sent on a network that everyone agrees we own. So it is inconceivable to me how they could claim that you bought this network and I'm now sending emails on it, but I own that email and I can have a privileged communication on your network, despite the fact that our handbook.
Okay, so let me ask this, because maybe I'm not understanding the sequencing here. Were these emails, these allegedly privileged emails, were those created before the purchase of the alleged purchase of the domain name, or after the alleged purchase?
The 34 on your list that you specifically addressed, I believe those are all after the purchase. Don't think any are before, for what I can tell. I may be wrong, but our review of that is. So those are emails. They're
Absolutely not.
Well,
when was the purchase?
The purchase was in, I believe it was May of 2018. These are all, the emails that were attached to the summary judgment response were the interpretation of the APA. So they're before and after.
Hold on. They were related to the true-up dispute for River Run. Those are the ones we used. So they were emails they were using after on our network that we bought. So, if they were before, there's no doubt we bought those emails. We bought the email server and the emails. We bought all data, all files, all documents, all correspondence, everything. We also bought the URL names, but it's not just intellectual property that covers this. There's a provision called M, which is all the other stuff we sold. And that provision covers pretty much everything. It includes, files, records, data, correspondence. So we bought all of that because we're going to be running the business. So we bought all of that. We also bought the network, the URL name. So once we own that URL network name, they know that they continue to send emails. So this list here has, I think, most of them, Ms. Pettit, I won't represent all of them because I don't remember specifically, but a big chunk of them are post-sale that they're sending emails on our network, which we've told them in the handbook is, we own this, no expectation of privacy. The specific statement we make to those folks is assume any email you're sending is on company letterhead. So for any email post-acquisition, there is just no way they could claim privilege, right to expectation, but also we own it. It's as if my employees are here sending emails to lawyers talking about wanting to sue me. I own those emails and I own that network. The pre-emails, the ones before that, I think we own because I think we bought. And it's pretty clear from the exhibits that we submitted that we bought it. We were given administrative rights, which means we're the administrator. We attached an exhibit. We paid the bill for the Google account.
But the predecessor council agreed to quarantine all of the privileged emails.
I'll get to that, Your Honor, in a second, because I mean, there's a different issue for that, but I just want the court to know that the basis is that we bought this. So you can't, if there was a privilege, we own it now. We bought it. Ms. Pettit raised that issue with predecessor counsel. The predecessor counsel said, we think we own these. We think you've waived it. The exact same arguments. But they agreed for purposes of discovery back, and this is to her appendix at 136, they agreed that they would quarantine, and they told her what they quarantined it, which is they quarantined what they called top level emails. So if the lawyers were in the top level, back and forth between you and the lawyer, they quarantined those. If they were not in the top level, it doesn't appear that they quarantined it. So if I forwarded this communication from my lawyer to someone else, it appears that may have escaped quarantine. Now, we didn't know this all at the time that we got involved in this, but it appears from me reading this email that may be what they did, because it looks like they used attorney domain names. Like if it's to or from a certain attorney, we'll take that out. So of the bulk of emails, they quarantined a bit of it. And then when you ordered us to compel at Ms. Pettit's request, we wanted to make sure we had all emails. We actually contacted this firm and said, send us the stuff. They said, we'll send you what we can. There's a group quarantined. We won't send you that. So I got what I thought was non-quarantine, and then we ran searches based upon what we thought was responsive or relevant or needed. We produced about 17,000 emails. And within that, it looks like that some of those emails, for whatever reasons they did on the quarantine, wound up in this subset for it. Now, the issue of were these privileged, was the quarantine emails privileged, what's going on, it appears that was never resolved between the parties. It was never raised with us in a way that we would have focused on it. We were just trying to comply with your honor's order and Ms. Pettit's request to make sure we produced whatever we produced. And there is a giant deal of emails. We became concerned when we started seeing non-privileged emails that we felt should have been produced in this litigation by the other side. And we also came across emails which we've attached as exhibits to us, where it appears that Mr. Harrison and Mr. Hume knew we owned DSN News and talked about how to forward emails and attempt to delete emails because they were concerned we had access to those emails. We also told some of the employees, including Ethan Hume, that we were migrating those people off DSN News, and so people knew exactly what was going on. But with respect to what happened here, it appears that we got access to, because we were given voluntarily the administrative access to the email system, because it was at least understood we were going to own and operate the business and had access to those emails, and that the asset purchase agreement contemplated that. They then continued, Mr. Hume as an employee, Mr. Harrison testified he was sort of our acting CFO. They continued to use that network. We now own it. Those are our emails. So to me, this is an issue.
So let me make sure I understand about Mr. Harrison's role. Mr. Harrison was Mr. Hume's attorney, or Mr. Hume and F.
Neither are attorneys, Your Honor. Neither are attorneys. What? Neither are attorneys. Mr. McCullough, Doug McCullough is an attorney in this case, but neither Harrison nor Hume are
Mr. Okay, Mr. McCullough, I apologize. Mr. McCullough is, whose attorney was he?
My client's attorney.
Your client's attorney, okay.
Yes.
But it's unclear. So the emails sent post-acquisition, it's unclear in what capacity they are seeking legal advice from, to be totally honest with Your Honor, at least the ones that we attached. Now, we took these and we attached them to our summary judgment motion. No one raised any issue for at least 60 days. I believe some of these might have been used in the Delgado trial, but I won't represent that, but we think there was some of these have been floating around because a big bulk of these emails were produced in November 2020, approximately a year before we got involved. So many of these emails have been out there floating around. We made a subsequent production of 16,000, I think, give or take, in when was it, guys? December, like January of this year. But I haven't traced all of them to figure out which of these have been out there. So to be honest with Your Honor, we are claiming that either they weren't privileged because we acquired them, they weren't privileged because you knew we owned the network when you sent them, or to the extent any privilege attached to this has long since been waived because the emails have been out there. The court may recall we had a whole summary judgment hearing, and I used some of those as evidence on the true-up claim, which the court denied summary judgment on it without objection. The only objection was authentication to those. And so I believe there's a serious waiver issue here with respect to it. And so we don't agree that there's this blanket finding that there's been no waiver. We don't agree that there's a presumption that these are their emails or there's a presumption of privilege. I would, therefore I can't agree, unfortunately, to her relief. I agree going through 2 million emails to try and figure out what is and isn't privilege is not productive at this time. And I'll represent to the court, we've never gotten access to, nor been given access to, the quarantined emails that the predecessor firms did on it. So I'll just tell the court, and with Ms. Pettit, I would never intentionally look at, or try and get access to privileged documents of another party, and certainly not with respect to Ms. Pettit. And so we thought in good faith that what we got was segregated. Everyone knew this is the stuff out there that'd been quarantined. So, but it looks like there had been some discussion as to what they were quarantining and what the issues were and what all was going on. And then we use these in summary judgment without objection. The snapback rule is 10 days once you know something's out there. I wouldn't hold anyone to that. We've certainly missed that deadline, but we argued the effect of some of that evidence, and the court has already entered an order on that. So
I'm not changing my ruling on that.
May I respond, Your Honor?
Can you go back to number 20? So the solution that you've asked for is, so there's 4 things you've asked for. So confirmation from the court that FPH's claims of privilege have not been waived just because FSG accessed the documents. That's granted. FPHs can make specific claims of privilege in response to any document offered by FSG at trial. I don't want this to be a big fight at trial. So you guys need to come up with a mechanism where if there's anything that's going to be offered by the defendant in this case that is allegedly privileged, then it needs to be objected to at the pretrial. I don't want to try to do this at trial.
Yes, of course, Your Honor. That was our intent. When we file objections, we would object to privilege if any of them are fit within these categories that we're objecting to.
And then these documents here, 28273 to 28277. What are these? These are the documents you showed me earlier on the.
No, Your Honor, I'm not showing you those because I don't want to deal with another waiver issue. Those were documents that Mr. Tillotson attached to their summary judgment response. We did object at that hearing, and we filed this motion to exclude within 4 days of it. So to say that we didn't object is completely inaccurate. We objected at the hearing and in writing within 4 days. So I don't want to put those on the screen. I will tell you that those are emails back and forth between my client and Mr. McCullough regarding the interpretation of the APA at issue in front of Your Honor. They're exhibit 51 and 52. If Mr. Tillotson wants to show them to you, that's certainly fine, but I don't want to, just in an abundance of caution for waiver, I don't want to put them
so
up there.
There's 2 issues here. One that I think is fairly black and white. The other one I think is much more gray, which is any, and I'm going to rule that any document, any communication between McCullough or Pettit or their firms and FPH or Hume prior to the purchase of the APA, or prior to the APA, that's going to be excluded. So I don't know. Seems to be some debate about which one of those or which of these are excluded. For the remainder, I would need to look at them to make a determination as what were they seeking legal advice for FPH, or were they seeking legal advice for SFG, or they were seeking legal advice for some other entity.
Sure. Your Honor, if I may, Mr. Harrison's affidavit proves up all of the documents in A6 as them seeking legal advice from Mr. McCullough for FPH, and that is uncontroverted. So everyone on both sides has these documents. Mr. Harrison filed an affidavit. They've seen the documents, and no one is disputing that this was legal advice sought for FPH, my client.
Is that accurate, Mr. Tillotson?
Well, Mr. Harrison says a lot of things. I don't necessarily agree he's proven up the privilege in an appropriate manner. Our argument, though, without fighting over that, is you sent those on our network that we own, and we told you have no expectation of privacy. I think that refutes any effort for him to establish that these are privileged documents.
Your Honor, I do have to jump in one more time. There is no network. Mr. Tillotson's talking about a network that doesn't exist. They bought URLs. They did not buy email accounts. The email accounts are the Google account that has been owned by my client. The evidence that we attached and is uncontroverted is that that Google account has always been owned by my client. Mr. Hobgood, who's Mr. Tillotson's CFO, is talking about the exact same thing that Mr. Harrison has sworn to in his affidavit, which is it's our Google account that we merely let them borrow because they were not set up to run a business.
It's weird they let us borrow by making us pay for it for every single month. I mean, that's the weird thing, is we were paying for it.
Yes, my client was locked out, which included the right to make payment on it. When we were locked out, we could not even pay for it.
Right. No, they gave us administrative access, which made
guys. Okay, so I get it. I've heard this argument. I've made my ruling. If you prepare an order on this, anything that was prepared, any emails that were for the purpose of legal advice between FPH, any emails between those two individuals, between the attorneys and Mr. Hume prior to the APA, that's going to be excluded, are going to be found to be privileged. Anything after the APA, it needs to be established that it was for the purpose of legal advice between FPH and or Hume and the attorneys. And I don't know if that's disputed or not. If that's not disputed, then all of these emails would need to be excluded. But that's the ruling, guys. Thank you so much. I'm sorry, I don't mean to be short, but I have another hearing I got to get to, and I also have.
Well, I appreciate that. Thank you for the time.
All right, just for clarity, so I make sure we get the proposed order right. Is there a ruling on the documents in Exhibit A6 where Mr. Harrison has confirmed that those were sought for legal advice on behalf of my client?
I understood, Your Honor, those would just fall into your prior ruling.
That those, if those were for the purpose of obtaining legal advice for FPH or Hume, then they would be excluded.
Okay.
Your Honor, just real quick, do we have any update on potential jury trials, or whether we're going to have an extension from February 10th? Just
who's speaking? I'm sorry.
I'm sorry. It's Katrina Ish, counsel for Southfield.
When is your trial set?
The 22nd. So we have exchanges starting
22nd of February, I assume, right? No, the current situation is, as I understand it, and it's in the order, Judge Moore just adopted an order, a local administrative district judge, is that jury trials are suspended in the George Allen Courthouse, and I don't want to misstate it, but essentially suspended until February 10th. There is no determination after that. So there may be jury trials on February 22nd. There may not be. We don't know.
Okay. Are you going to be conducting the bench trial on the 22nd? I don't think we've even established that we would be doing the bench trial the 22nd yet.
I am trying if I'm not doing jury trials, I'm trying every bench trial I possibly can right now.
Okay, understood. Okay, I think.
I'm sorry, I don't remember. Are both the jury trial and the bench trial set on the 22nd?
They are, Your Honor.
They
so
are.
If I'm not in another trial, at least one of those will go on the 22nd.
Okay. So our position, of course, still is that our jury trial cannot be conducted at the same time as the bench trial. So I guess we can work in the background on that, but we still argue that it would be prejudicial because literally like 5% of overlap of their 22 claims going on. Like we have one claim against us. I don't know if you recall these issues.
I do recall, and I mean I can't read the future. I don't know what's going to happen. Whether or not we're going to have jury trials. My inclination is if we're not having jury trials, I'll probably just try the bench trial that day, that whatever, it shouldn't take too long, and just knock that one out of here, because who knows when we'll actually reach. Mr. Tillotson will probably tell you that he has a trial the week before in my court that I imagine will be a multi-week trial that may knock us out of all of this if it goes. So, you can ask him about the details on that.
All right. Well, we will try to see if we can work some stuff out in the background with the other parties.
Thank you, guys.
Thanks, Sean. Thanks for the time. Bye, Julie.
Problem. And I don't mean to be, I'm sorry, I'm kind of rushed here. Garcia versus Romero. Anyone here on that case?
Yes, Your Honor. Heather Neese on behalf of the plaintiff, Mildred Garcia.
Reagan Ewing on behalf of the defendant, Jerome Aneloro.
This one's a simple one. I'm sorry, it's been a long day. I'm going to have to go through this kind of quickly. So there's a request to take the deposition of the adjuster to try to find the name of the information on the defendant, to try to get his address and any identifying information to be able to find him. Is that right?
Your Honor, yes, I think all of that is correct. I don't know if it's necessarily I'm looking at the motion. I don't see that it's, let me look at the order though, that it's necessarily a deposition. We're just asking them to provide us with the address, last known address for the Jose Romero in order for us to get him served.
Ms. Ewing, you're going to need to turn that over. Either the adjuster is going to come down here and at the courthouse, and we're going to do a show cause. You just need to turn that information over.
Yes, Your Honor, and we've let them know. So they said that they should be contacting plaintiff's attorney.
Okay. Get me an order on that, Ms. Neese. Thank you so much, guys. Sorry to keep you kind of rush you here. It's been a long day. Just get me an order. When you do the order, Ms. Neese, if you can go ahead and make sure it says at the beginning that this was heard on January 31st, 2022, and that you share it with Ms. Ewing to make sure it corresponds with my ruling. And please email my court coordinator a copy of it as well as e-file it. Okay?
Yes, Your Honor. And is there a specific date that you would like them to provide us that information?
Within 2 weeks.
2 weeks. Thank you, Your Honor. We'll get that to you.
Thank you, guys.
Thanks.
You guys have a great day.
You too.